Before we begin, a quick and important disclaimer. This video provides an academic and linguistic analysis of the language used within the United States legal system, specifically regarding family law and divorce proceedings. The content presented here is strictly for educational and entertainment purposes. It does not constitute legal advice, nor does it establish an attorney-client relationship. The legal landscape is complex and varies significantly by jurisdiction. Therefore, the historical trends and case studies discussed may not apply to your specific situation. Viewers are strongly encouraged to conduct their own due diligence and consult with a licensed professional before making any decisions related to legal matters. The most expensive mistake you will ever make in a courtroom is not what you do, but the specific words you choose to describe what you did. In a landmark study of over 3,000 pages of courtroom transcripts, researchers discovered a terrifying correlation. The difference between a favorable settlement and a total financial collapse often came down to the precise use of linguistic hedging and modal verbs by the lead attorneys. We often think of divorce as a battle of facts, a tallying of who spent what and who did what. However, sociolinguists have begun to uncover a hidden architecture within the American legal system. There is a coded dialect spoken by divorce lawyers, a strategic lexicon designed to strip away emotion, quantify human affection, and manipulate the narrative arc of a failing marriage. If you don't understand the phonetics of power, you are essentially walking into a high-stakes negotiation speaking a foreign language while your opponent is fluent. This is not just about law, it is about the weaponization of the English language. By the end of this deep dive masterclass, you will understand exactly how the top 1% of U.S. divorce attorneys use linguistic anchoring to influence judges and de-escalate or escalate conflict at will. We are going to deconstruct the lexicon of dissolution, showing you how the shift from active voice to passive voice can literally save a client hundreds of thousands of dollars in alimony. You will learn to recognize the neutrality trap, a specific verbal technique used during depositions to bait a spouse into an emotional outburst that can be used as evidence of instability. This is the problem we are solving today: the bridge between the raw, chaotic emotion of a breakup and the cold, clinical and high-stakes reality of the United States judicial system. We are giving you the academic toolkit to see the invisible threads of communication that dictate the outcome of the most significant transition in an adult's life. To understand this, we must first examine the shift from the language of fault to the language of no fault. Historically, in the United States, divorce required a linguistic villain. You had to prove adultery, cruelty, or abandonment. This created a specific type of legal rhetoric, one filled with moral superlatives and accusatory syntax. Let's look at the phrase irretrievable breakdown through an academic lens. This is what linguists call a nominalization. It takes a complex, multi-year process of human suffering and turns it into a static clinical noun. By calling a marriage a breakdown rather than a failure caused by X, the lawyer removes human agency. This is a strategic move. In case studies of high-conflict divorces in California and New York, the use of nominalized language has been shown to reduce the heat of the transcript. When a lawyer says, "There has been a breakdown of communication," they are creating a linguistic distance between their client and the conflict. It makes the divorce seem like a natural disaster, an inevitable event like an earthquake, rather than a series of choices. This clinical detachment is the first tool in a lawyer's arsenal to signal to a judge that they are the rational actor in the room. Beyond simple word choice, we have to look at the syntax of blame. In professional legal discourse, the agent of a sentence is the person doing the action. A skilled divorce lawyer will often utilize the agentless passive to protect their client. For example, instead of saying, "My client spent $40,000 on a luxury vehicle without consulting the spouse," the lawyer might say, "The funds were allocated toward a vehicle purchase during the fiscal year." Notice what happened there. The client, the agent, has vanished. The money wasn't spent by a person, it was allocated. This shift from a transitive verb, where someone does something to something else, to a statutory passive, changes the entire psychological weight of the statement. Historically, transcripts show that judges are less likely to fixate on specific financial indiscretions when they are phrased as systemic occurrences rather than individual choices. We also see the use of temporal markers to define the standard of living. This is a critical area where language translates directly into dollar amounts. In the U.S., alimony, often called spousal support, to sound more clinical and less punitive, is based on the marital standard of living. A lawyer will use adverbial intensifiers to inflate or deflate this reality. They won't just say the couple went on vacations. They will say they consistently maintained a global travel itinerary. By using consistently and maintained, they are establishing a linguistic baseline. They are creating a verbal contract of expectation. On the opposing side, a lawyer might use diminutives. They might describe the same lifestyle as occasional expenditures or intermittent luxury. The battle is fought in the adjectives. One of the most fascinating academic findings in this field is the psychology of the pronoun. In initial consultations, clients almost always use we and us. They are still linguistically tethered to the unit. A professional divorce lawyer, however, will immediately begin a process of pronominal dissociation. They will force the client to say I and he or she. This is not just a legal necessity. It is a psychological rebranding. By changing the pronouns, the lawyer is restructuring the client's reality to prepare them for the adversarial nature of the U.S. court system. Case studies in forensic linguistics show that clients who fail to make this pronominal shift are more likely to make concessions against interest during negotiations because they still view their spouse as part of their linguistic in-group. Furthermore, we must address the euphemisms of custody. In recent years, there has been a massive linguistic shift from custody and visitation to parenting time and decision-making responsibility. This isn't just about being polite. The word custody has carceral connotations. It implies a prisoner and a guard. By shifting the language to parenting time, lawyers are using positive reframing to lower the stakes of the negotiation. However, the underlying legal power remains the same. The lawyer uses these soft terms to facilitate a settlement, while simultaneously embedding rigid clauses in the fine print. They might use the term liberal access, which sounds generous and flexible, but in a legal context it is often a linguistic trap because liberal is not a defined measurement of time. This ambiguity often leads to future litigation, which, historically, is a trend that benefits the legal profession's longevity. The most advanced technique used by elite attorneys is lexical mirroring. This is when a lawyer adopts the specific vocabulary or speaking pace of a judge or a mediator to build subconscious rapport. If a judge uses the word equitable frequently, the lawyer will pepper their arguments with equitable rather than fair. While the words are synonyms, equitable carries a specific legal weight in the U.S. Chancery or family court tradition. Fair is for children. Equitable is for the court. By mirroring the court's language, the lawyer signals that they belong to the legal in-group, making their arguments more likely to be perceived as sound law. As we move forward into the next parts of this study, we will look at how these linguistic patterns are used in high-conflict depositions, where the goal is to use leading questions to create a linguistic anchor that the witness cannot escape. We will see how a single word like always or never can be used to destroy a witness's credibility through a process called extreme universalization. This is the foundation of the masterclass. Understanding that in the realm of U.S. divorce law, language is the primary currency, and the most successful players are those who know how to manipulate its value. To understand how this linguistic weaponization manifests in real time, we must enter the most controlled environment in the United States legal system, the deposition. Imagine a sterile conference room in downtown Chicago. It is now June 2026, and we are looking at the case of John, a high-earning software architect, and his spouse. This is not a trial. There is no judge. It is just John, two opposing attorneys, and a court reporter. In this setting, the lead attorney for the spouse is not looking for the truth in a philosophical sense. They are hunting for linguistic anomalies. They are looking for the moment John's language deviates from his established narrative. This is where the academic concept of lexical precision becomes a matter of financial life or death. One of the most effective tools used by top-tier U.S. divorce lawyers is the exploitation of what linguists call minimizers. In our 2026 case study, the attorney asks John about a series of wire transfers made to a separate account. John responds by saying, "I just moved that money to cover some personal expenses." In that single sentence, the word just is a linguistic flair. From an academic perspective, just is a restrictive adverb used to downplay the significance of an action. By using it, John has subconsciously signaled defensiveness. A skilled lawyer will immediately pivot, knowing that when a witness uses a minimizer, they are attempting to shrink the perceived scale of an event. The attorney will then follow up with a technique known as the expansion loop. Instead of asking why he moved the money, the attorney will ask, when you say just, are you suggesting that $50,000 is an insignificant sum in the context of the marital estate? By isolating the word just, the lawyer has anchored the entire conversation around John's perceived arrogance or lack of financial transparency. This leads us to the strategy of extreme universalization. In the heat of a high-stakes divorce, the human brain tends to revert to binary thinking. We see this in the frequent use of the words always and never. Historically, transcript data from across the United States shows that these two words are the most common points of failure for witnesses. Imagine a scenario where the attorney asks John, "Did you always consult your spouse before making major purchases?" John, feeling the need to defend his character as a collaborative partner, says, "Yes, always." This is a catastrophic linguistic error. In an academic sense, John has created a universal affirmative. He has left no room for error. The lawyer then produces a single receipt from 2024 for a high-end bicycle that was not discussed. By finding one single exception, the lawyer hasn't just proven John lied about a bicycle, they have linguistically dismantled his entire credibility. The logic presented to the court later is simple. If he was untruthful about always in this small instance, he cannot be trusted when he says always regarding his income or his fidelity. The goal of the lawyer is to force the witness into a linguistic corner, where their own vocabulary becomes the cage. We must also analyze the use of the tag question. This is a grammatical structure where a declarative statement is turned into a question by adding an interrogative fragment at the end, such as, "Isn't it?" or "Wouldn't you agree?" For example, the lawyer might say, "You wanted to ensure your spouse had no access to these funds, didn't you?" The tag question is a form of linguistic coercion. It is designed to lead the witness toward a specific conclusion, while making it feel like they are the ones providing the answer. In sociolinguistic studies of U.S. courtroom behavior, tag questions are used significantly more often by the dominant speaker to assert control over the narrative flow. If John answers yes, he confirms the negative intent. If he says no, he appears combative. The only linguistic escape is to reject the premise entirely, but few witnesses have the academic training to recognize the syntax of the trap while they are under the physical stress of a deposition. Another critical area of study is the weaponization of the passive voice to deflect agency. While we touched on this in the first part, the application in financial discovery is nuanced. In 2026, we are seeing a trend where lawyers use nominalizations to turn actions into things. Instead of saying John hid assets, a defense lawyer will say there were complexities in the account structure. By turning the act of hiding into the noun complexity, the lawyer removes the person from the act. It shifts the focus from a moral failing to a technical misunderstanding. This is a step-by-step process of narrative reframing. Step 1. Identify the damaging action. Step 2. Convert the verb into a noun. Step 3. Surround that noun with bureaucratic adjectives. The result is a sentence that is technically true but emotionally vacant, which is exactly what a lawyer wants when presenting a client's less-than-ideal behavior to a judge. Let us look at the concept of linguistic anchoring in the context of the current year. In 2026, the sheer volume of digital communication, texts, Slack messages, and encrypted app data has changed the lawyer's lexicon. We now see the rise of textual tonality analysis. Lawyers are no longer just looking at what was said, but the frequency and timing of the communication. A lawyer will point to a series of one-word replies from a spouse as evidence of stonewalling, a specific linguistic behavior used to exert power by refusing to engage. They will contrast this with the other spouse's long, explanatory paragraphs, which they will label as collaborative efforts. Even though the content of the short messages might be factually correct, the linguistic structure is used to paint a picture of emotional abuse or negligence. The lawyer is essentially performing a literary analysis of a text thread to influence a legal outcome worth millions. Consider an imagine-if scenario. Imagine if every time you spoke to your partner during the last 3 years of your marriage, there was a third person in the room taking notes not on your feelings but on your syntax. Imagine if every sarcastic joke was categorized as verbal aggression, and every missed call was logged as a breach of parental responsibility. This is the reality of the U.S. legal system in 2026. The lawyer's job is to take the raw data of your life and filter it through a lexical sieve. Only the words that fit the desired legal theory are allowed through. This creates a curated reality. The depth of this linguistic manipulation goes even further when we consider the illusion of choice questions. A lawyer might ask, did you decide to withhold the documents because you were confused, or because you were trying to gain a tactical advantage? This is a false dilemma. Both options lead to a negative conclusion. Academically, this is known as a double bind. By providing only two paths, the lawyer is attempting to narrate the witness's internal state for them. The goal is to get the witness to pick the lesser of two evils, but in doing so, they have still admitted to the core negative action. As we conclude this part of our masterclass, we have to recognize that the language of divorce is a language of attrition. It is designed to wear down the opponent's linguistic defenses until they default to simple, high-emotion responses that can be easily weaponized. We have explored the traps of universalization, the power of tag questions, and the clinical shield of nominalization. But there is a deeper level to this study. There is a way that these linguistic patterns actually influence the biology of the listener, the judge. How do certain vowel sounds and cadence patterns in an opening statement actually trigger a sympathetic response in the brain of a presiding official? And more importantly, how do elite lawyers use the silence between their words to create a vacuum that the witness feels compelled to fill with damaging admissions? In the next part, we will explore the phonetics of persuasion and the terrifying power of the tactical pause. We will see how the most successful lawyers in the country use the physical sounds of the English language to tilt the scales of justice before a single piece of evidence is even introduced. The tactical pause is the most underestimated weapon in the United States divorce lawyer's arsenal. It functions through a psychological mechanism known as the Zeigarnik effect, where the human brain experiences an intense internal tension when a task or a linguistic interaction is left incomplete. In the high-pressure environment of a 2026 deposition or courtroom hearing, this tension becomes almost unbearable for the untrained witness. When an attorney asks a piercing question and then simply stops, maintaining neutral eye contact, they are creating a vacuum. Historical trends in courtroom observation show that witnesses who feel the need to be liked or understood will often fill this vacuum with what sociolinguists call over-explanation or linguistic spilling. They provide details they were never asked for simply to resolve the psychological discomfort of the silence. Let us examine a case study involving a veteran litigator in Miami, whom we will call Sarah. In a 2026 litigation involving a complex valuation of a technology startup, Sarah utilized the tactical pause to devastating effect. Her client was a spouse seeking an equitable distribution of a cryptocurrency portfolio that had seen massive gains between 2023 and 2025. The opposing spouse, John, claimed the private keys to the primary cold storage wallet had been lost in a hardware failure during a move. During a recorded deposition, Sarah presented a series of transaction logs from the public blockchain that showed activity from the supposedly lost wallet as recently as 3 months prior. Instead of immediately accusing John of perjury, she placed the logs on the table, asked him to explain the outgoing transfers, and then she remained silent for 20 seconds. In a legal setting, 20 seconds is an eternity. The silence forced John to look at the logs, then at his own attorney, and finally back at Sarah. This length of silence created a psychological feedback loop, where John began to imagine the vast extent of evidence Sarah might possess that she had not yet revealed. Eventually, the pressure became too great, and John spoke, attempting to explain the activity as an automated script he had forgotten to disable. That admission that he still had control over the automated scripts was the crack in the door Sarah needed. It proved he still had the functional capability to interact with the wallet, effectively dismantling his hardware failure defense. The silence did the interrogation for her. Moving from the absence of sound to the qualities of sound itself, we must analyze the concept of prosody. This refers to the rhythm, stress, and intonation of speech. In the United States, there is a distinct difference between the way a lawyer speaks to their own client versus how they address the opposing party. When a lawyer wants to project absolute certainty to a judge, they utilize the authoritative drop. This is the practice of ending a declarative statement on a significantly lower pitch than the beginning of the sentence. This downward inflection triggers a subconscious association with finality and objective truth in the listener's brain. Imagine if you are a judge in a crowded 2026 family court docket, listening to two conflicting accounts of a prenuptial agreement's validity. One lawyer speaks with high-rising terminals, the habit of making statements sound like questions, often called upspeak. This is frequently perceived as a sign of low confidence or lack of preparation. The other lawyer speaks in a steady rhythmic cadence with consistent downward inflections at the end of every sentence. Even if the evidence presented is identical, studies in legal psychology suggest that the judge is predisposed to find the second lawyer more credible. This is because the human brain processes steady, low-frequency sounds as more stable and less threatening than erratic, high-pitched speech. The authoritative drop effectively turns a legal argument into a perceived fact. In 2026, we also observe the strategic use of lexical density to influence the court's perception of professionalism. Lexical density refers to the ratio of content words, nouns, verbs, and adjectives, to the total number of words used. High-performing divorce attorneys tend to increase their lexical density when speaking to the court. They replace common Germanic root words with their more complex, Latinate counterparts. Instead of saying the marriage ended, they say the union was terminated. Instead of saying the father took the children, they say the respondent exercised his parenting time. This serves a dual function. First, it reinforces the lawyer's status as an expert who is fluent in the specialized language of the law. Second, it creates a linguistic barrier between the raw human tragedy of the situation and the clinical legal process. By using Latinate vocabulary, the lawyer is essentially sanitizing the conflict, making it easier for a judge to make a mathematical decision about asset division. Step by step, the implementation of this phonetic strategy involves the calculated use of plosives. Step 1. Identify the core fact you want the judge to remember most. Step 2. Select words for that fact that contain strong plosive consonants like P, T, and K. These sounds require a complete blockage of the vocal tract followed by a sudden release of air, creating a sharp, percussive sound that naturally grabs the human ear. For example, saying the defendant took the money is linguistically weaker than saying the respondent pocketed the profits. The P sounds in pocketed and profits act as phonetic anchors, making the phrase more memorable and impactful when the judge later reviews their notes. Furthermore, the speech rate is used as a tool for cognitive load management. When a lawyer wants to gloss over a weak point in their own case, they will slightly increase their words per minute. This is designed to outpace the listener's ability to critically analyze the flaws in the logic. Conversely, when they reach a crucial piece of evidence that favors their client, they will slow down significantly, increasing the space between each word. This ensures the judge has ample time to encode the information into their long-term memory. It is a form of verbal bolding, achieved without ever needing to raise the volume of the voice. The biological impact of these choices is grounded in the science of psychoacoustics. When a lawyer uses a deep, resonant voice, they are tapping into evolutionary triggers that associate lower frequencies with larger, more powerful, and therefore more reliable entities. In a 2026 meta-analysis of U.S. family court proceedings, it was found that attorneys who maintained a consistent pitch within the 80 to 120 Hz range were consistently rated as more persuasive by legal observers. This is a neurological shortcut. The judge's brain, often fatigued by hours of complex data, seeks the path of least resistance. A calm, resonant, and rhythmically predictable voice provides that path, reducing the cognitive load required to process the information and making the speaker's conclusions feel more like the judge's own independent thoughts. We have now dissected the silence, the sounds, and the rhythmic structure of the lawyer's lexicon. We have seen how a 12-second void can uncover a hidden asset, and how the authoritative drop can transform a mere suggestion into a perceived fact. But what happens when the words on the page and the sounds in the air are not enough? What happens when the lawyer begins to manipulate the very structure of your memories? In the next part of this masterclass, we will delve into the realm of the invisible narrative. We will explore how lawyers use presupposition and entailment to plant ideas in the minds of the court, without ever stating them directly. We will look at the dangerous power of the loaded question, and how to spot a linguistic landmine before it detonates your entire case. How can a lawyer make you admit to something you didn't do? Simply by the way they frame the history of your relationship. The answer lies in the deep structure of English semantics, and that is where we are going next. Presupposition is the legal equivalent of a Trojan horse. In the field of linguistics, a presupposition is an implicit assumption about the world or a background belief relating to an utterance whose truth is taken for granted. For a U.S. divorce lawyer in 2026, this is not just a grammatical curiosity. It is a surgical tool used to bypass the conscious defenses of a witness. When a lawyer asks a question that contains a presupposition, they are not just seeking information. They are planting a fact into the record without ever having to prove it. If the witness answers the question directly, they have linguistically ratified the hidden assumption. Let us return to our 2026 case study involving John and the alleged concealment of digital assets. Imagine John is sitting across from an attorney named Marcus, who specializes in forensic asset tracing. Marcus does not ask, "Did you hide the cryptocurrency?" That is a binary question that allows John to say no. Instead, Marcus asks, At what point did you realize that the offshore digital wallet was no longer in compliance with the updated 2025 financial disclosure regulations? This question is a masterpiece of semantic engineering. It contains what linguists call a factive presupposition. The use of the verb realize presupposes that the following clause, that the wallet was not in compliance, is an objective truth. By asking when John realized it, Marcus has skipped the debate over whether the wallet existed or whether it was out of compliance. He has moved the goalposts to the timeline of John's awareness. If John answers with a specific date, he has admitted to owning a non-compliant wallet. If he says he never realized it, he has still implicitly admitted the wallet exists. This technique relies on the brain's natural tendency to focus on the foreground of a sentence. In 2026, cognitive load is higher than ever due to the constant stream of digital information, and under the stress of a legal proceeding, the human brain often fails to scan the background assumptions of a complex sentence. This is where we see the application of the selective memory frame. Lawyers will use temporal markers to rewrite the history of a marriage. Imagine if Marcus asks, "Why did your pattern of financial volatility increase after the 2024 fiscal quarter?" The phrase "your pattern of financial volatility" is a definite description. It assumes that such a pattern exists as an established fact. Academically, this is known as an existential presupposition. The lawyer is not asking if there was volatility, they are asking for the cause of it. In many case studies, witnesses who are eager to explain their actions will provide a reason, such as, "I was under a lot of stress at work." In that one sentence, the witness has linguistically conceded that their financial behavior was volatile. They have handed the opposing counsel a weapon that will be used to argue for a restricted distribution of assets or a lower alimony award. Step by step, the construction of a presuppositional trap follows a rigorous logic. Step 1. Identify a damaging conclusion you want the court to reach. Step 2. Embed that conclusion into a subordinate clause or a noun phrase. Step 3. Ask a question about a secondary detail related to that phrase. This forces the witness to either perform a linguistic rejection, which often looks combative or evasive to a judge, or to accept the premise. For example, consider the parenting capacity trap. Instead of asking, "Are you a distant parent?" a lawyer might ask, "How do you compensate for the emotional distance your children feel when you are working late at the firm?" The emotional distance is the presupposition. To fight this, the witness must stop and say, "I reject the premise that my children feel emotional distance." However, in the fast-paced environment of a 2026 hearing, most people are conditioned to be cooperative and will simply try to answer the how. We must also analyze the concept of entailment. In formal semantics, entailment is a relationship between sentences where if sentence A is true, sentence B must also be true. High-level divorce attorneys use this to lead a witness down a path of logic that ends in a self-inflicted wound. Imagine if Marcus gets John to agree to a series of seemingly harmless statements. Sentence A. You value financial transparency in your business dealings. Sentence B. Your personal tax returns for 2025 were prepared using the same software as your business filings. Sentence C. The business filings have since been flagged for audit. Through the logic of entailment, John has now linguistically linked his personal credibility to a flawed business audit. The lawyer doesn't need to call John a liar. They have created a semantic net where John's own previous admissions entail his current unreliability. There is also the weaponization of iteratives, words like again, still, and anymore. These words carry a massive amount of historical baggage. If a lawyer asks, "Is your spouse still afraid of your outbursts?" the word still presupposes that the spouse was afraid in the past. This is a common historical trend in U.S. domestic litigation. It allows a lawyer to introduce a history of conflict into the record without presenting a single police report or witness statement. The word still does all the heavy lifting. If the witness answers no, they are implying that the fear existed before but has stopped. If they answer yes, they are confirming its continued existence. The only safe answer is a metalinguistic correction. My spouse was never afraid of me. There were no outbursts. But the mere presence of the question in the transcript creates a negative linguistic anchor for the judge. In 2026, we are seeing the rise of the narrative sieve, a technique where lawyers use specific lexical choices to categorize a decade of marriage into a few clinical themes. Imagine if your entire relationship was reduced to the terms cohabitation, resource allocation, and parenting intervals. This is not just a change in vocabulary. It is a restructuring of reality. By using these terms, the lawyer is stripping away the human element of the marriage making it easier for the court to treat the family as a failing corporation. We see this in case studies where one spouse is described as the primary breadwinner while the other is the domestic manager. These are not just job titles. They are linguistic boxes that dictate the potential outcomes of the settlement. The domestic manager is framed as dependent, while the primary breadwinner is framed as the source of agency and power. Furthermore, we must consider the architecture of a loaded question. This is often a question that contains a presupposition that is both damaging and difficult to extract. In the US, the rules of evidence are supposed to prevent these, but a skilled lawyer knows how to mask them as foundational questions. For instance, how many times did you hide the mail before your spouse discovered your gambling debt? This question contains two presuppositions: that you hid the mail and that you have a gambling debt. This is a double bind. Even if the witness denies hiding the mail, the mention of the gambling debt remains in the air, creating a psychological stain on their character. As we conclude this exploration of the deep structure of legal semantics, it is clear that the battle of a divorce is fought long before the final decree is signed. It is fought in the definitions, the assumptions, and the tiny, invisible words that hold a sentence together. We have looked at the Trojan horse of presupposition and the inescapable net of entailment. But there is a final, even more subtle layer to this academic study. How do lawyers use the very metaphors of our language to frame the entire concept of the family? How does the shift from a marriage as a partnership to a marriage as a contract change the way a judge perceives your right to your own future? In the next part, we will analyze the metaphorical framing of the American family and the power of the conceptual anchor. We will see how calling a marriage a journey versus calling it an investment can lead to two completely different legal destinies. We will explore the subtle art of the closing argument, where these metaphors are woven together to create a final, inescapable narrative for the court. The core of any legal argument in a United States courtroom is not a list of facts, but the primary metaphor through which those facts are interpreted. According to conceptual metaphor theory, pioneered by linguists like George Lakoff, human thought processes are largely metaphorical. We do not just speak in metaphors, we reason through them. In the high-stakes environment of a 2026 divorce proceeding, the lawyer who successfully installs their dominant metaphor into the mind of the judge often dictates the potential outcomes of the entire case. This is because metaphors function as a cognitive filter. Once a judge accepts the metaphor of marriage as a business venture, they will naturally look for data points related to investment, return on capital, and profit sharing. If they accept the metaphor of marriage as a sacrificial covenant, they will instead focus on duty, betrayal, and moral restitution. Let us examine a detailed case study from a 2026 litigation in Seattle. We have Emily, a former data scientist who left her career in 2018 to manage the household and support her husband, Mark, as he built a series of successful artificial intelligence startups. By 2026, the marital estate is valued at $30 million. Mark's lead attorney begins the opening statement by utilizing the metaphor of marriage as a limited partnership. Step 1 in this linguistic strategy is to categorize all domestic labor, using the language of infrastructure and support services. Mark's lawyer does not say that Emily raised the children. He says she provided the essential domestic infrastructure that allowed the primary revenue-generating entity, Mark's career, to scale efficiently. This is a brilliant and cold application of the business metaphor. By calling Emily's decade of parenting infrastructure, the lawyer is subtly demoting her from a partner to a service provider. In a business, a service provider is paid a market rate, but they do not necessarily own half of the intellectual property created by the CEO. Historically, this type of framing is used to argue for a buyout, rather than an ongoing equitable split. The lawyer will use terms like seed capital to describe the initial funds Mark brought into the marriage, and portfolio diversification to explain why Mark's recent investments should be considered separate property. They are treating the marriage like an LLC that has reached its dissolution date. Imagine if you are the judge listening to this. You are being asked to look at a human life through a spreadsheet. To counter this, Emily's lawyer must deploy a more powerful, competing metaphor. In 2026, we see the rise of the opportunity cost metaphor. Emily's lawyer argues that the marriage was not a business, but a singular career path where one person was chosen to be the face of the brand, while the other was the silent co-founder. By using the term co-founder, the lawyer is linguistically reclaiming Emily's status. They will speak of Emily's stunted earning capacity not as a misfortune, but as a strategic reallocation of human capital. Step by step, Emily's attorney builds a narrative of career cannibalization. They argue that Mark's success did not happen alongside the marriage, but because it consumed Emily's professional future. This utilizes the metaphor of time as a finite resource. In the United States legal system, time is money, and by framing Emily's years spent at home as a permanent loss of professional velocity, the lawyer is creating a linguistic debt that the court feels compelled to repay. They will use the term professional sunset to describe the reality that a data scientist who has been out of the field for 8 years in the fast-paced world of 2026 AI can never truly return to their previous level. This metaphor of a sunset suggests an inevitable and irreversible conclusion, which justifies a higher demand for long-term spousal support. We also see the deployment of the shipwreck metaphor in high-conflict cases. When a marriage ends in a sudden, traumatic fashion, perhaps involving the discovery of a secret life or financial fraud, the lawyer will use language that evokes a natural disaster. They will speak of the debris of the relationship and the salvage operation required to protect the children. This is designed to trigger the judge's protective instinct. If the marriage is a shipwreck, the judge is not just an arbiter. They are a rescue coordinator. This framing shifts the focus away from a cold division of assets and toward the concept of emergency relief. Historically, cases framed as disasters result in more immediate and aggressive temporary orders for support, as the court feels a sense of urgency that is absent in a clinical contract dispute. Conversely, a lawyer representing a client who wants a quiet, low-cost exit will use the managed dissolution metaphor. They will speak of the marriage as a chapter that has reached its natural conclusion. They will use words like evolve, transition, and amicable uncoupling. This is the language of the controlled burn. By suggesting that the end of the marriage is a healthy and necessary evolution, they are linguistically discouraging the judge from looking for a villain. This is particularly effective in 2026 no-fault jurisdictions like California or New York, where the court's primary goal is efficiency. If the lawyer can make the divorce seem like a routine administrative task, the judge is less likely to dig into the messy details that might favor the other side. The power of these metaphors lies in their ability to create an associative net. When a lawyer uses the word investment, the judge's brain automatically pulls in related concepts like risk, reward, and maturity dates. When the lawyer uses the word journey, the brain pulls in concepts like companionship, destination, and shared experiences. In a 2026 study of jury and judicial reactions, it was found that once a dominant metaphor is established in the first 10 minutes of a trial, the listeners will actually ignore facts that do not fit that metaphor. This is known as confirmation bias through framing. If the judge believes the marriage was a business, they will view a spouse's emotional testimony as unprofessional and irrelevant. If they believe it was a journey, they will view the same testimony as crucial evidence of the relationship's trajectory. Furthermore, we must look at the spatial metaphors used to describe the division of property. Lawyers will talk about one spouse being left out in the cold or the other spouse being stripped bare. These are metaphors of physical vulnerability. They are designed to bypass the intellectual brain and hit the emotional core. In 2026, where digital assets like virtual real estate and tokenized property are becoming standard parts of the marital estate, these physical metaphors are even more important to ground the judge in the reality of the loss. A lawyer might say, "My client is being evicted from the digital life they helped build." By using the word evicted, a term associated with the loss of a physical home, the lawyer is making the loss of a cryptocurrency account feel visceral and urgent. As we conclude this deep dive into the metaphorical architecture of the law, we see that the American divorce lawyer is not just a student of statutes, but a master of the human imagination. They do not just argue what the law is, they argue what the marriage was. But there is another darker side to this linguistic mastery. What happens when the lawyer stops speaking to the judge and begins to speak directly to the other spouse's subconscious? How do elite attorneys use the negative suggestion and the linguistic double-bind to force an opponent into a mental state where they are willing to sign away their rights just to make the talking stop? In the next part of this masterclass, we will explore the dark arts of legal persuasion, including the use of gaslighting syntax and the weaponization of cognitive dissonance in settlement negotiations. We will see how a simple email from an attorney can be structured to trigger a physiological panic response in the recipient, and how to identify these patterns before they compromise your ability to think clearly. The battle is moving from the courtroom into the mind, and the tactics are about to get much more aggressive. The psychological battlefield of a 2026 high-net-worth divorce is constructed through a linguistic phenomenon known as the illusion of inevitability. This is a sophisticated form of verbal conditioning where an attorney uses specific syntactic structures to convince the opposing party that their defeat is not just likely, but already a historical fact. Academic studies in forensic linguistics have identified that the most effective way to trigger this state is through the use of presuppositional adverbs and false consensus markers. When a lawyer begins a sentence with words like obviously, clearly, or as you are well aware, they are not simply stating a fact. They are performing a linguistic heist. By framing a contested point as something that is already mutually agreed upon, they force the recipient's brain to choose between accepting a false premise or engaging in the exhausting task of constant confrontation. Imagine if you are David, a successful business owner in Austin, currently navigating a complex dissolution in the summer of 2026. You receive an email from your spouse's lead counsel. The letter does not ask if you intend to share the proceeds of a recently vested stock option. Instead, it reads, since you have obviously already accounted for the tax implications of the stock vesting in your proposed settlement figures, we should now move to the distribution schedule. This is the gaslighting syntax in action. The word obviously functions as a cognitive bypass. If David responds to the distribution schedule, he has implicitly agreed that the stock options are part of the marital pot, and that he has already calculated the taxes. He has been linguistically coerced into a consensus he never actually joined. This leads us to the weaponization of cognitive dissonance. In a legal context, this involves creating a linguistic environment where a person's self-image is placed in direct conflict with their legal strategy. A lawyer might say to David during a settlement conference, "A man of your professional standing and reputation for integrity would surely want to ensure his children's future is not compromised by a protracted legal battle over a few percentage points of equity." This is a masterpiece of identity-based persuasion. By tethering David's reputation for integrity to a specific legal concession, giving up equity, the lawyer is making it psychologically painful for David to fight for his assets. To fight the equity split is now linguistically equivalent to admitting he lacks integrity or does not care about his children. Historical trends in U.S. mediation show that participants are significantly more likely to make financial concessions when those concessions are framed as a test of their moral character. We must also analyze the devastating power of paralipsis, often referred to as the negative suggestion. This is the practice of bringing up a damaging topic by explicitly stating that you are not going to talk about it. In a 2026 deposition, an attorney might say, "I am not here to discuss your history of substance use, or how it may have impacted your judgment during the 2025 fiscal year. I only want to talk about the missing ledger entries." By mentioning the substance use while pretending to dismiss it, the lawyer has successfully planted the idea of instability and poor judgment into the record and the mind of everyone in the room. Academically, this is known as an ironical process. The brain cannot process a negative without first conceptualizing the positive. If I tell you not to think of a blue elephant, you must think of a blue elephant to understand what not to think about. By the time the lawyer moves on to the ledger entries, the shadow of substance use is already coloring every answer David gives. Step by step, the implementation of this psychological pressure often begins with the demand letter. In 2026, these are no longer just legal documents. They are structured to trigger specific physiological responses. Researchers using sentiment analysis on thousands of U.S. legal documents have found a trend toward what is called high-frequency hostility. The letter is structured with short, punchy sentences and a high density of imperative verbs. Step 1. Use a formal cold salutation to establish distance. Step 2. State a series of deadlines that are intentionally difficult to meet, creating a sense of time poverty. Step 3. Use loaded nouns like misappropriation, negligence, and bad faith to describe routine financial movements. This structure is designed to induce a cortisol spike in the recipient. When David reads that he has 48 hours to provide 10 years of records or face immediate sanctions for his blatant obstruction of justice, his prefrontal cortex, the part of the brain responsible for rational decision-making, begins to shut down. He moves into a fight-or-flight state. In this state, he is much more likely to instruct his own lawyer to just make it go away, leading to a settlement that favors the aggressor. The lawyer is not just practicing law, they are practicing neurochemistry. Another dark art is the use of the subtle imperative disguised as a question. Instead of telling David what to do, the lawyer will ask, "Have you considered the potential outcomes of a public trial on your company's upcoming IPO?" The word potential outcomes is the legal safe word here, but the question is a threat. It uses the availability heuristic, a mental shortcut that relies on immediate examples that come to a given person's mind when evaluating a specific topic. By mentioning the IPO and a public trial in the same breath, the lawyer forces David to visualize the worst-case scenario. The fear of that visualization becomes the primary driver of the negotiation, rather than the actual facts of the law. Case studies from 2026 show that this is particularly effective in the realm of digital reputation. A lawyer might suggest that the discovery process will involve a deep dive into all private messaging platforms, adding, "We would, of course, prefer to keep these private matters out of the public record for the sake of the family." This is a classic protection racket framed as a professional courtesy. The linguistic subtext is clear. Settle now on our terms, or we will weaponize your private data. The lawyer uses the phrase "for the sake of the family" as a linguistic shield to mask the underlying extortionate nature of the statement. Furthermore, we must look at the concept of linguistic anchoring in the context of numbers. When a lawyer opens a negotiation by demanding 80% of the marital assets, they know they will not get it. However, they have established a numerical anchor. Academically, this is known as the adjustment and anchoring bias. Every subsequent offer will be judged in relation to that 80%. If the lawyer eventually settles for 60%, they have framed it as a 20% concession, making David feel like he has won a victory, even though the original 80% figure was linguistically arbitrary. The lawyer uses precise, non-rounded numbers like 78.4% to make the anchor seem like it is based on a rigorous calculation rather than a strategic whim. As we conclude this part of the masterclass, we have unmasked the syntax of gaslighting, the traps of cognitive dissonance, and the physiological warfare of the demand letter. We have seen how a lawyer can use your own integrity as a lever against your bank account. But there is another level of this academic study that is even more influential. Beyond the two spouses and their lawyers, there is a third silent participant in every divorce: the judge. How does the language of the courtroom change when the lawyers are no longer trying to intimidate each other, but are instead trying to perform a subtle form of linguistic inception on the person wearing the black robe? How do they use the hidden codes of judicial deference to signal that they are the only adults in the room? In the next part, we will explore the language of the bench and the art of judicial flattery. We will see how the most successful U.S. attorneys use specific linguistic markers to align themselves with the judge's own ego, effectively turning the court into an extension of their own legal team. The game is about to move from the mind of the opponent to the heart of the system itself. The transition from the adversarial dynamics of a deposition to the performative space of a courtroom requires a total linguistic recalibration. In the heart of the United States judicial system, the primary audience is no longer the opposing party or the court reporter. It is the person on the bench. To understand the language of a top-tier divorce lawyer in 2026, we must analyze the concept of intellectual ingratiation. This is not the crude flattery of a sycophant, but a precise, data-driven alignment with a judge's specific legal philosophy and vocabulary. By 2026, elite law firms utilize advanced linguistic analytics to scrape every publicly available ruling and transcript from a presiding judge. They identify what we call lexical favorites, specific phrases or legal doctrines the judge relies on most heavily to justify their decisions. Imagine if you are David, standing in a courtroom in Houston in October 2026. Your lawyer is not just presenting evidence about your business valuation, they are performing a subtle form of linguistic inception. If the judge, let us call her Judge Hernandez, has historically shown a preference for the term fiduciary stewardship when discussing marital assets, your lawyer will weave that exact phrase into the opening argument at least 4 times. This creates a cognitive ease for the judge. When she hears her own preferred terminology coming from your lawyer, her brain subconsciously categorizes your side of the case as more legally sound and intellectually compatible with her own worldview. This is the first step in the strategy of becoming the adult in the room. A lawyer achieves this status by practicing linguistic distancing. This is the calculated gap between the client's emotional reality and the lawyer's clinical precision. While David might want to yell that his spouse is a liar, the lawyer will state that the respondent's testimony contains significant internal inconsistencies that fail to align with the forensic accounting records. The lawyer is signaling to the judge that they are both part of the same professional in-group, the rational, logic-driven elite. By contrast, if the opposing lawyer allows their client to speak in emotional superlatives, or if they adopt a high-pitched, aggressive tone, they are linguistically isolating themselves from the judge. Historical trends in family court show that judges are predisposed to favor the party whose representative speaks the language of the bench, a language of statutes, precedents, and calm, multisyllabic Latinate terms. We must also examine the architecture of the request for discretion. In the U.S. legal system, judges have immense power in family law to make equitable decisions. A lawyer does not demand a result, they invite the court to exercise its wisdom. This involves the use of honorifics and deferential syntax. Instead of saying, "You should give David 60% of the house," the lawyer says, "We respectfully submit that the court, in its vast discretion, may find that an upward deviation in the asset split is the only way to satisfy the requirements of equity." The phrase "we respectfully submit" is a linguistic shield. It acknowledges the judge's power while simultaneously suggesting the desired outcome as a logical inevitability. It removes the ego from the lawyer and places the crown on the judge, making the judge more comfortable with granting the request. Step by step, the lawyer builds this judicial rapport through a process called the echo effect. Step 1. Listen to the judge's questions during the initial motion. Step 2. Identify the specific adjectives the judge uses to describe the conflict. If the judge asks if the parenting plan is stable, Step 3 is to ensure every subsequent witness and document uses the word stability as its primary anchor. By echoing the judge's own concerns, the lawyer makes the judge feel heard and understood. This is a powerful psychological tool because humans are naturally inclined to agree with people who reflect their own internal dialogue. In 2026, we also see the rise of the technical amicus persona. The lawyer stops acting like a partisan warrior and starts acting like an unbiased expert advisor to the court. They might say, "Your Honor, we recognize the complexity of these tokenized real estate holdings, and our goal today is simply to provide the court with the most transparent valuation model possible." By framing their goal as transparency rather than winning, they disarm the judge's natural skepticism toward adversarial counsel. They are positioning themselves as the judge's partner in solving a difficult puzzle. This is particularly effective in complex financial cases where the judge may feel overwhelmed by the data. The lawyer who provides the most digestible, clinically phrased explanation becomes the judge's most trusted source of information. Case studies from 2026 indicate that the use of archaisms, older legal terms, is also on the rise as a way to signal professional gravity. Terms like stare decisis, de minimis, or prima facie are not used to be pretentious. They are used to trigger the judge's professional identity. When a judge hears these terms, they are reminded of their role as a guardian of the law rather than a referee of a domestic spat. It elevates the entire proceeding. If the opposing counsel uses slang or overly casual language, they are linguistically demoting the court, which can be perceived as a subtle form of disrespect, even if it is unintentional. Furthermore, we must analyze the weaponization of the passive voice for judicial protection. If a judge makes a ruling that is technically incorrect or unfavorable, a skilled lawyer will never say "you are wrong." Instead, they will use a passive structure. It appears that a crucial piece of the 2025 financial disclosure was not fully incorporated into the previous analysis. This phrasing allows the judge to change their mind without losing face. It suggests that the error was a systemic occurrence rather than a personal failure of the judge. By protecting the judge's ego, the lawyer keeps the door open for a more favorable ruling in the future. Imagine if your entire legal strategy was built on the foundation of how another person likes to hear themselves think. This is the reality of elite representation. The lawyer is a linguistic chameleon, shifting their tone, their vocabulary, and their very cadence to match the person behind the bench. They are building a bridge made of words, designed to carry their client across the chasm of a potential financial disaster. But there is a final critical element to this study. While the lawyer is busy influencing the judge, they must also manage the most volatile element in the room, their own client. How does a lawyer use language to transform an angry, heartbroken spouse into a composed, credible witness? How do they use the linguistic makeover to strip away a client's natural personality and replace it with a version that the court will find sympathetic? In the next part of this masterclass, we will explore the witness coaching lexicon and the art of verbal de-escalation. We will see how lawyers use role-play and specific word-swapping techniques to ensure that when David takes the stand, he doesn't sound like a man losing his family, but like a man who is the epitome of the stability the judge so desperately craves. We will look at the specific words that are forbidden on the witness stand and the phrases that can instantly turn a judge against you, no matter how much evidence you have. The transformation is about to begin. The witness stand in a United States courtroom is not a place for truth-telling in the way we understand it in daily life. It is a stage for the performance of a specific linguistic identity. In the high-stakes environment of 2026, where every spoken word is instantly transcribed by AI and analyzed for sentiment by opposing counsel. The lawyer acts as a dialect coach. The goal of this coaching is a process known as linguistic neutralization. This is the systematic removal of all high-arousal language, emotional superlatives, and subjective moralizing. The objective is to transform a grieving or angry spouse into an objective observer of their own life. If the witness speaks from their heart, they lose. If they speak from a script of clinical observation, they have the potential for far more favorable outcomes. Imagine David, our software architect from Chicago, preparing for his testimony in late 2026. In his initial meetings with his lawyer, David uses what linguists call effective language. He says things like, "It was devastating when she lied about the secret bank account. It was just so unfair." His lawyer immediately stops him. In a 2026 courtroom, the words devastating, lied, and unfair are linguistic landmines. Devastating is an emotional claim that a judge cannot quantify. Lied is a legal conclusion that the witness is not qualified to make. Unfair is a playground complaint that carries zero weight in an equitable distribution state. The lawyer begins the linguistic makeover by teaching David to replace these words with what we call descriptive evidence. Step 1 of this makeover is the shift from internal state to external observation. Instead of saying, "It was devastating," David is coached to say, "I was surprised by the discovery of the account because it had not been disclosed during our annual financial reviews." Instead of saying, "She lied," he is taught to say, "The existence of this account was inconsistent with the financial statements provided to me in 2025. By using the word inconsistent, David is no longer attacking his spouse's character. He is pointing out a data discrepancy. This is a crucial distinction. Judges in 2026 are weary of the pop psychology lexicon. Words like toxic, gaslighting, or narcissist have become so overused in social media discourse that they now trigger a negative credibility bias in many presiding officials. When a witness uses these labels, the judge often perceives them as being coached by the internet rather than presenting facts. The forbidden lexicon is a list of words that a professional divorce lawyer will strike from a client's vocabulary during the preparation phase. At the top of this list is the word fair. In an academic study of thousands of hours of U.S. family court proceedings, it was found that the more a witness uses the word fair, the less likely they are to receive the specific outcome they desire. This is because fairness is a subjective moral concept, whereas the court operates on the principle of equity. Equity is a mathematical and legal calculation based on statutes and historical trends. When David says, "It's not fair that I have to sell the house," he sounds entitled. When his lawyer says, "The forced sale of the marital residence would create a significant tax liability that outweighs the immediate liquidity benefits," he is speaking the language of the court. The client is coached to never ask for what is fair, but to always describe what is sustainable or consistent with the established standard of living. Another forbidden word is should. In linguistics, should is a modal verb of obligation that implies a moral judgment. Saying, "She should have stayed home with the kids," sets David up as a judge of his spouse's behavior. The court does not care about what someone should have done. It only cares about what they did and the resulting impact. The lawyer will swap should for the language of resultant impact. David is coached to say, "When the children were left with a third-party caregiver for extended periods, I observed a regression in their bedtime routines." Notice the word observed. It positions David as a witness of fact, not a critic of parenting style. The word regression provides a clinical hook for the judge to latch onto. We must also look at the strategic use of epistemic modals, which are words used to express the speaker's degree of certainty. In everyday conversation, we use hedges like "I think," "maybe," or "I guess" to be polite. On the witness stand in 2026, these are signs of weakness that an opposing attorney will exploit. However, the opposite extreme, absolute certainty, is equally dangerous because of the trap of extreme universalization we discussed earlier. The lawyer teaches David the middle path of recollection. Instead of saying, "I am 100% sure I paid the mortgage every month," David is taught to say, "To the best of my recollection, the mortgage payments were made from the joint account on the first of each month." This phrasing provides a linguistic buffer. If the opposing counsel finds one late payment, David has not committed perjury. His recollection was simply incomplete. He has used a hedge not to be polite, but to be legally bulletproof. In 2026, custody battles are often won through the stability script. This is a specific vocabulary designed to trigger the judge's preference for continuity. The lawyer will provide David with a list of anchor words: routine, structure, consistency, developmental milestones, and primary caregiver. Imagine if David is asked about his relationship with his daughter. He might want to say, "I love her more than anything, and we have so much fun together." While heartwarming, this is linguistically useless in court. Instead, David is coached to say, "I have been responsible for her morning routine and academic supervision since 2023, ensuring she meets all her developmental milestones in a consistent environment." This sentence uses 4 anchor words and 20 words of speech. It paints David as a functional parent rather than just an emotional one. The coaching also involves the art of the non-responsive response. When an opposing lawyer asks a loaded question like, "Isn't it true you're just fighting for the house to spite your wife?" David is taught to avoid the emotional bait. He is taught the technique of lexical reframing. He might answer, "My interest in the property is based on maintaining the children's school district and ensuring a stable residential environment for their continued growth." He didn't say yes and he didn't say no. He reframed the question from one of spite to one of child-centered stability. This is a high-level linguistic maneuver that requires hours of role-play to master. Step by step, the lawyer will review David's past communications, his texts from 2025, his emails from 2024, and perform a linguistic audit. Every time David used a high-arousal word in the past, the lawyer will help him develop a clinical explanation for it today. If David called his spouse crazy in a text message 2 years ago, he must now explain that as a poorly phrased observation of emotional volatility. He is essentially translating his past self into the language of his current legally sanitized self. As we conclude this part of the masterclass, we have seen how the witness is rebuilt from the ground up, word by word. We have explored the forbidden lexicon and the power of the stability script. We have seen how the language of observation defeats the language of emotion. But even the most perfectly coached witness can still be destroyed by the one thing they cannot control, the physical evidence of their digital life. How do lawyers in 2026 use AI to perform a semantic sentiment analysis of 10 years of your private messages to prove a pattern of behavior you didn't even know you had? And how do they use the concept of digital footprint discrepancy to make you look like a different person than the one sitting on the stand? In the next part, we will move into the world of forensic linguistics and big data. We will see how every emoji, every timestamp, and every deleted thread is woven into a linguistic net that can catch even the most well-prepared witness. The evidence is no longer just what you say, it is what the data says you meant. In the legal landscape of 2026, we have transitioned from the era of the paper trail to the era of the semantic footprint. Forensic linguistics, once a niche academic pursuit, has become the primary investigative engine in high-stakes United States divorce litigation. The fundamental shift lies in the realization that while a witness can be coached to change their oral testimony, they cannot retroactively sanitize 5 to 10 years of digital existence. By utilizing advanced semantic sentiment analysis, or SSA, forensic linguists can now map the emotional and cognitive baseline of a marriage with terrifying precision. This process involves the ingestion of every text message, email, Slack thread, and social media interaction into a neural network designed to identify deviations from a person's linguistic norm. Consider the 2026 case of David, whose coach testimony on the stand presented him as a pillar of emotional stability. Opposing counsel utilized a tool common in modern discovery, known as lexical vector mapping. This technology does not just look for keywords like angry or money. It analyzes the relationship between words in a high-dimensional vector space. In David's case, the AI identified a significant linguistic schism. While his current testimony utilized a neutrality index of 0.85, his private messages from the previous 3 years showed a hostility density that increased by 400% whenever the topic of marital assets was mentioned. The step-by-step forensic process begins with data ingestion, followed by baseline establishing, where the AI determines David's natural writing style, his idiolect. The third step is anomaly detection. For David, the anomaly was not just what he said, but the syntactic fragmentation that occurred during specific months. His sentences became shorter, his use of imperative verbs increased, and his punctuation became erratic. In a 2026 court, this is not just a sign of stress. It is presented as forensic evidence of a premeditated intent to destabilize the spouse during financial negotiations. Imagine if every text you ever sent was viewed not as a private thought, but as a data point in a pattern of coercive control. Forensic linguists in 2026 are particularly interested in the concept of linguistic fingerprinting. Every individual has a unique way of structuring their thoughts through language, a set of habits involving word frequency, function word usage, and even the specific way we use or omit the Oxford comma. If David claims he did not write a specific email that contains damaging admissions about hidden cryptocurrency, a forensic linguist can perform a stylometric analysis. They compare the suspect email against 20,000 words of David's known writing. By calculating the frequency of n-grams, sequences of n items from a given sample of text, the expert can determine the probability of authorship with a degree of accuracy that often exceeds 95%. In historical trends from the early 2020s, such evidence was rare. By 2026, it is a standard component of the discovery phase in U.S. family law. Furthermore, the 2026 legal system has officially recognized the concept of effective punctuation and emoji syntax. In an academic study of recent New York and California case law, judges have begun to accept the interpretation of emojis as formal indicators of intent. For example, if David sends a message regarding a financial settlement followed by a specific series of emojis, the court no longer views them as mere decorations. They are analyzed as nonverbal modifiers that provide context to the text. A lawyer might argue that a seemingly neutral statement like, "I will take care of the accounts," followed by a specific emoji, constitutes a veiled threat or an admission of an intent to conceal. This is where the concept of the lexical anchor becomes critical. A single emoji can act as a linguistic anchor that fixes the meaning of an otherwise ambiguous sentence, preventing a witness from later claiming they meant something else. We must also analyze the concept of temporal cluster analysis. This is the study of not just what is said, but the timing and frequency of the communication. In 2026, discovery includes the metadata of every digital interaction. If David's messages to his financial advisor always occur within minutes of a heated exchange with his spouse, the lawyer uses this temporal proximity to prove a direct causal link between marital conflict and the movement of assets. Step 1. Map the timestamps of all conflict-laden messages. Step 2. Overlay those timestamps with financial transaction logs. Step 3. Use the resulting clusters to demonstrate a pattern of retaliatory financial conduct. This linguistic temporal data is far more difficult to explain away than a single piece of paper, as it shows a systemic behavior over years, rather than an isolated incident. Another critical development in 2026 is the analysis of syntactic mirroring and its absence. In a healthy relationship, partners often subconsciously adopt each other's linguistic habits, a phenomenon known as communication accommodation. Forensic linguists look for the moment this mirroring stops. The sudden cessation of linguistic alignment is often the first measurable sign of what the court calls de-identification. If David stopped mirroring his spouse's vocabulary 6 months before the divorce was filed, but continued to project the image of a committed partner, the lawyer will use this data to argue that David was engaging in strategic dissimulation. Essentially, that he was linguistically preparing for a divorce while keeping his spouse in the dark to gain a tactical advantage. Imagine a scenario where your own grammar is used to prove you were planning a departure long before you admitted it to yourself. This brings us to the myth of the deleted thread. In 2026, forensic tools can reconstruct a linguistic ghost of a deleted conversation by analyzing the responses and subsequent behavior of the participants. Even if David deletes his side of a conversation, his spouse's replies provide a semantic shadow that allows an AI to infer David's original statements with high probability. The court views the act of deletion itself as spoliation of evidence, and the linguistic reconstruction serves as a powerful tool for the judge to draw a negative inference. Finally, we have the emergence of the digital footprint discrepancy. This is the gap between a person's public persona and their private syntax. A lawyer in 2026 will present a side-by-side comparison of David's professional LinkedIn posts, written in high-density, collaborative language, versus his private messages, which might be filled with low-density, aggressive, and dismissive syntax. This discrepancy is used to destroy the witness's credibility by proving they have the capacity to maintain a false persona. The argument is simple. If David can linguistically manipulate his professional network, he can certainly linguistically manipulate the court. As we move toward the conclusion of this masterclass, we have seen how the digital world has stripped away the ability to hide behind a coached testimony. We have explored the power of stylometry, emoji syntax, and temporal clustering. We have unmasked the linguistic ghost and the semantic footprint. But there is one final overarching theme that connects all of these academic threads. How does this entire linguistic system culminate in the final decisive moment of the trial? In the final part of this series, we will analyze the closing narrative and the linguistics of the final decree. We will see how the most elite U.S. divorce lawyers take all of this data, the metaphors, the pauses, the coach testimonies, and the forensic findings, and weave them into a single inescapable story that forces the judge's hand. We will look at the language of the settlement agreement and the specific clauses that act as linguistic time bombs, designed to explode years after the divorce is final. This is the ultimate synthesis of everything we have learned, and it determines who actually walks away with the future they envisioned. The end of the study is here, and the final revelation will change the way you view every word you speak for the rest of your life. The closing argument is the moment where the lawyer transitions from a collector of data to a weaver of myth. In the United States judicial system of 2026, this final performance relies on a psychological mechanism known as narrative transportation. This is the state in which the judge becomes so cognitively immersed in the story being told that they lose their inclination to critically analyze individual, conflicting facts. The elite divorce attorney does not simply recap the evidence. They perform a final synthesis, a linguistic event that takes every disparate thread we have discussed, the tactical pauses, the nominalized passive voice, the business metaphors, and the forensic digital footprints, and fuses them into a single inescapable reality. They are no longer arguing about what happened, they are defining what always was. Consider the conclusion of David's case in 2026. After weeks of testimony, his lead counsel stands to deliver the summation. This is a step-by-step application of cognitive ease. The lawyer uses a technique called the primacy of the pattern. They do not start with the bank accounts or the house. They start with the character arc. They frame the entire decade of the marriage as a steady progression toward a singular point of failure. By using a rhythmic, repetitive sentence structure, a rhetorical device known as anaphora, the lawyer builds a sense of momentum. Every sentence starts with the same phrase. A marriage built on transparency does not hide digital wallets. A marriage built on partnership does not prioritize solo ventures. A marriage built on truth does not require a forensic linguist to uncover its history. By the fourth repetition, the judge is subconsciously nodding in time with the cadence. The lawyer has established a linguistic baseline of what a marriage should be, and David, through his previously analyzed lexical schisms, has been effectively excluded from that definition. This brings us to the most dangerous document in the entire process, the final decree of dissolution. While many clients view this as the end of the war, academics in legal linguistics view it as the launchpad for future conflict. The language used in these decrees is often intentionally layered with what we call strategic ambiguity. In 2026, we see a historical trend where attorneys include clauses that seem clear but are semantically hollow. A classic example is the phrase reasonable notice for parenting time adjustments. From a linguistic perspective, reasonable is a relative adjective. It has no fixed mathematical or temporal value. What is reasonable to David, who works in the high-velocity world of software architecture, is fundamentally different from what is reasonable to a stay-at-home parent managing a rigid school schedule. By embedding these subjective terms into a permanent legal order, the lawyer ensures that the potential outcomes of the decree include a high probability of future litigation. This is the linguistic time bomb. It is a clause designed to expire only when the parties reach a new point of friction, necessitating a return to the court for a clarification of terms. Imagine if your entire future was governed by a word as unstable as substantial. In the context of alimony or spousal support, many U.S. states allow for a modification only if there is a substantial change in circumstances. But what constitutes substantial? In our 2026 case study, when David's company eventually went public, his income shifted from a base salary to a complex structure of restricted stock units. Is this a change in the nature of the income, or a substantial increase in the amount? The lawyer who drafted the original agreement knows that the word substantial acts as a semantic gateway. It is a word that requires a judge to interpret it, and that interpretation requires a new set of lawyers, a new set of fees, and a new battle of metaphors. The depth of this trap is found in the merger and incorporation clauses, where the language of a private settlement is swallowed by the language of the court, giving the state the permanent power to define the words you once chose for yourselves. Step by step, the lawyer prepares the client for the post-decree reality through a process of semantic satiation. This occurs when a word or phrase is repeated so often that it loses its meaning for the speaker, becoming merely a series of sounds. By the time David signs his final papers in late 2026, he has heard the words equitable distribution and best interests of the child so many thousands of times that they have become noise. He signs the document not because he fully agrees with the linguistic nuances, but because he is experiencing decision fatigue. The lawyer, however, remains linguistically sharp. They are looking at the boilerplate clauses, the standard language that most people ignore. They are checking for the presence of the word shall versus may. Shall is an imperative modal that creates a mandatory obligation. May is a permissive modal that grants discretion. A single word swap in a 60-page document can mean the difference between a mandatory college fund contribution and an optional suggestion. The final revelation of our masterclass is that the United States legal system is not a search for truth, but a competition of grammatical consistency. The party that walks away with the most favorable outcome is usually the one whose narrative contained the fewest linguistic anomalies. In David's case, the forensic sentiment analysis of his messages proved to be the ultimate anchor. The judge's final ruling used David's own words against him, citing his shift in syntax as evidence of a lack of candor. The judge's written opinion mirrored the lawyer's metaphors, describing David's financial actions as a breach of fiduciary stewardship. This is the ultimate victory for a lawyer, when the judge adopts their vocabulary so completely that the ruling reads like it was written by the attorney themselves. But what happens after the decree is signed? This is the realm of the residual narrative. The language used during the divorce becomes the primary dialect of the post-divorce relationship. If the process was filled with the language of war and betrayal, the parties are linguistically conditioned to view every future interaction through that lens. However, in 2026, we are seeing a shift toward collaborative lexicons in some jurisdictions, where lawyers are incentivized to use integrative bargaining language. Instead of a winner-take-all syntax, they use the language of value creation. They move away from the binary of mine and yours, and toward the language of mutual sustainability. This is not out of kindness, but out of a realization that high-conflict language is a diminishing return for the court system's efficiency. As we conclude this deep dive, we must acknowledge the sheer scale of the linguistic architecture that surrounds us. From the first disclaimer to the final decree, every word is a calculated move in a game of high-stakes human chess. We have seen how the passive voice can hide a fortune, how a 12-second pause can break a witness, and how a business metaphor can redefine a family. The final lesson is that you do not live in a world of facts. You live in a world of descriptions. And in the United States legal system, the person who controls the description is the person who controls the future. The study of this language is never truly over because English is a living organism, constantly evolving to create new traps and new avenues of persuasion. As we look toward the next phase of forensic tools, we must ask ourselves, what happens when the AI is not just analyzing your words, but predicting them before you even speak? What happens when the law begins to regulate your internal intent based on the predictive syntax of your digital life? We have opened the loop on the power of language, and in our next deep dive, we will explore the terrifying emergence of predictive jurisprudence and the end of linguistic privacy. The words you speak today are the evidence of tomorrow, and the net is only getting tighter.